Right. So we have Ramona Weick, who's a former visiting fellow of our center. She's a doctoral candidate at Heidelberg University, who will talk about her research on GDPR compliance automation. We have Victor Maranhão and Igor Macedo, who are the co-founders of Juristel, out of Brazil, talking about their company. And then we have Argiri Banesi, who's a professor at IE Law School in Spain, and a fellow at the Digital Civil Society Lab at Stanford, talk about e-access to court material and ethical and privacy issues surrounding electronic access to court material. So, so before we have an hour, I would ask the speakers to stay in sort of within 20 minutes for both their presentation and Q&A. So you could sort of perhaps limit your remarks to about 10 minutes or so, and then keep the rest for discussion with the group. That would be fantastic. And then before I turn it over to Ramona, I wanted to see if anyone wanted to share any news with the group, any updates to report. Please speak up now. All right, Rachel raised her hand. Rachel, are you there?
Okay. Yes, I'm starting a PhD next week at the University of Nottingham at their Horizon CDT program. And my subject's going to be looking at AI and the law. So it's going to be an interesting mix of interdisciplinary subjects.
Fantastic. And this is you pitching a research project there, or you're hosting the pitching event, or?
I've got an idea of what I want to do for my research, but it's a 4-year program with the first year looking at the focus of my PhD thesis. I'm looking to put together some research papers looking at the interplay between AI platforms and how they behave together, especially in terms of the law and how people perceive the law.
Okay, fantastic, thank you. All right, anyone else? Any news to report? No? Well, then let me turn it over to Ramona. Ramona, are you there?
Yes, I'm here. Thank you, Roland, for the introduction. Great. I'm going to share my screen really quick. Hi, good to see you again.
All right, over to you.
Yeah, I'm going to need about 15 minutes just to say right now. As Roland said, my name is Ramona, and I've been a visiting student researcher at CodeX until about the end of March this year. I'm very happy to be here today since I had to cancel my last scheduled talk in March in order to catch one of the last flights back to Germany in the middle of the pandemic. So anyway, it's good to see you again, and I've picked a part of my research today that I've been working on within the last month, so let's jump right into it. Probably everybody knows the situation. You receive newsletters you didn't subscribe to, or suggestions doing online shopping regarding what you should buy that are somehow exactly suiting your needs at this current moment. A lot of times in the past, I've wondered what happened to my data as soon as I disclosed it, or where data has been collected without me being aware of it. The amount of data in this world is, and thus also within the US, is increasing rapidly. When we look at the enterprise share of the data sphere in the US, we can see an enormous growth of the enterprise, share of data, and also of the data in general, which relates to dynamics such as the spread of IoT devices, streaming instead of storing media, saving data in cloud storages instead of on your computers, or using big data and analytics. Thus, the share of enterprise data is increasing noticeably from not even 5 zettabytes in 2015 to approximately more than 30 zettabytes by 2025. Since more and more data...
Ramona, I'm so sorry to interrupt. Were you meaning to share some slides with us?
Oh, don't you see it? I'm sorry.
No.
Oh, I same mistake as before. Now you should see it, right?
There we go. Thank you.
Okay, so this was the first slide. I'm sorry. Let's go through it really quick. This was the first. This was the data sphere slide where you could see the increase of the amounts of data. And this was the slide which I was currently talking about. All right, more and more data is stored and not on your own computer, but in public or cloud storages. So awareness regarding what data is being collected, used, or shared diminishes. This is one of the reasons we have a right to access for data subjects in a general data protection regulation, also called GDPR. Before this law came into force, many European countries had different standards and laws regarding data protection, which led to different problems, for example, regarding international operating businesses. Among other things, these problems should be solved with GDPR. So what people in the EU can do is request access to their data according to Article 15 GDPR. Actually, there is a similar right for California consumers in the California Consumer Privacy Act, which just came into force in January this year. So some of the following explanations might apply to that as well, and it's not only affecting Europe, but however, in my research, I focus on GDPR only. A simplified structure of an access request in practice is quite easy to understand. If a request is being sent to a data controller, he has to search for the database, or in the database if there is any data of that data subject being stored or processed, and if that is the case, has to meet specific requirements regarding what the response has to include. This response then has to be transmitted to a requester in a safe manner. Sounds pretty easy. However, the process is quite error-prone because GDPR contains some undefined legal terms which have to be interpreted. There are some requirements and a lot of definitions that have to be extracted from other legal rules or even with the help of general principles of the Constitution. For example, that the identity of a requester needs to be verified before the requested information is sent to the data subject. In addition, there are recitals which are supposed to help with interpretation but don't have the same significance as the wording of the law. Together with a CS student, I requested and then evaluated more than 140 data subject access requests, which I'm going to call DSARs from time to time. And we found out that the whole process regarding how companies and employees deal with such requests is often neither standardized nor did we receive complete replies from many of the data controllers. It appeared that one of the reasons for this was that people responsible for replying not always have been lawyers, but for example, employees of the customer service department. Thus, they may not always have sufficient legal expertise regarding how to understand GDPR and how to handle the requests. Even more than 2 years after the GDPR came into force, there's a lot of potential for improvement. I think what is the reason why I chose to write my thesis in this field is that technology and automation are one of the key points for being compliant with DSARs. Not only would automation save employees valuable time and ensure completeness of the replies, it would also help requesters to understand the information they receive due to the system helping them with finding a transparent and easy way or easy to understand way of disclosing the relevant information, and thus could better estimate, for example, whether or not they want to exercise additional rights. DSARs, in my opinion, are a good research subject regarding automation because from the legal perspective, the rule structure, apart from the undefined terms and exceptions, is pretty simple. And from a practical perspective, DSARs happen frequently and are following a similar procedure. So what did I do to find solutions for these problems? First, I looked at the compliance workflow of DSARs. There's a lot that can be done with regard to the processes already. Among other things, data subjects can be helped submitting their requests with templates or via electronic means. Requests can be registered automatically. Identification processes could be automated more often. Databases can be searched and so on. Digitization of business workflows is already often being brought forward. But this is not where I wanted my research to go. Since I'm a member of a doctoral research group, Computational Law in Heidelberg, we focus on the digitization of legal rules themselves. The question is, how can a computer fulfill parts of the work on its own a lawyer would normally do? And how can it support legal reasoning of lawyers as well? There is one approach I choose to talk about today, which is rule-based systems which support data controllers in fulfilling DSARs. A model of a DSAR workflow is actually a good way to start when thinking about what a supportive system can and should do. This depends on by whom the system is supposed to be used. From my experience, help is needed, especially for those people with little legal background, who I already mentioned, and who often have to deal with these requests. Showing them how to do it and partly automizing some of the reasoning steps would probably help a lot. Therefore, we have to look at the requirements of GDPR and help the computer process them. This means we have to transfer the rules and sentences from natural language to a machine-readable language. After modeling the rules which an employee or lawyer has to comply with, we can build on this abstract representation. What is important for the formalization of legal text is that formalization of the semantics can be quite complicated, since the rules and components of them have to be unambiguous, which means that every time we find undefined or ambiguous context-related legal terms, there probably will be problems in formalizing the natural language text, and thus for later automation of legal reasoning as well. Besides the rules, we can model legal knowledge, such as GDPR principles, facts, or heuristics. For example, we can use ontologies to build formal models of terms and their relations. Besides other things, ontologies can help formalize the semantics of natural language. These ontologies can eventually be incorporated in a decision support system as a knowledge base, for example, and used for specific purposes such as semantic search or for giving suggestions. What needs to be mentioned is that rule-based decision support systems were not in the center of research for some decades due to different problems in the past, some of which were exaggerated expectations towards what these systems will be able to do, and the time-consuming modeling or adaptation of the knowledge bases. This is why often the pros could not offset the cons of these systems. Why I still do research in this field is for different reasons. First, in my area of research, almost any techniques of machine learning had to be excluded due to the lack of training data. And this is, still a quite new field of research. So also, case-based approaches would need a lot of cases which are not available yet and also hard to find in a machine-readable format. Second, several GDPR ontologies modeled for different purposes are already available. So whoever wants to make an effort to build a supportive system later could make use of what has already been modeled. Also, structured information is more and more accessible in standardized formats, often free of charge. And third, the more we kind of narrow the research area or model a potential supportive system from a comprehensive approach with a broad field of application to a narrow field of research, including legal rules incorporating a quite simple structure and rights that are frequently exercised, the more likely it can be successful. Both in general applies to the right of access, which in its core components contains clear if-else structures. And last, especially in this field of research, unreal expectations of a machine acting as a robot lawyer partly have to be given up, making room for semi-expert systems or so-called heteromation approaches as well, which means that the machine is supposed to act as a collaborator for the lawyer or employee. For example, it doesn't have to interpret a legal term completely on its own, but provide reasons for or additional knowledge for the person deciding on the current case. So this is what I can imagine a system or a supportive system to look like. The employee is being guided through a DSAR procedure, asked only the relevant questions according to the applicable rules. By the way, the little robot is only meant to show computer programs and not supposed to be a chatbot or something. For example, the system would ask whether there are doubts regarding the identity of the data subject, which depends, among other things, on how the request has been initiated. It could do so because it was given a fact that the request has been, for example, initiated electronically. Because identity verification is not regulated in Article 15, but rather in Article 12 and other provisions, cross-referencing within the GDPR thus can be respected as well. If there are doubts, the system, for example, would ask the employee to require additional identification data or to use mechanisms for identity checking, depending on how the business is organized. If a data controller uses databases, automatic searching and information retrieval systems could be combined and the relevant data could be collected. Even if the information collection would need to be performed manually, the system could guide the employee regarding what needs to be included. This part of the right of access is thankfully explained quite well in the statute because lists are given in which the required information is named explicitly. The employee would kind of need to check whether the proposed reply for the request is complete and transmitted to the data subject in a safe manner, or by providing a safe platform where the requester could retrieve the data and information. For the parts of GDPR that are not that explicit, however, for example, to find out when reasonable doubts regarding the identity of a data subject are indicated, the system could offer additional information from if there are any formal cases, similar rights with identity issues, recitals or commentaries on how to make sure identity is verified. Some approaches, for example, the one in Rabi et al. Also use guided weighting or assessment. Thus, in this approach, aspects of computational law are combined with aspects of process automation and compliance improvement. However, using ontologies as knowledge bases, even in this narrow field of application, is not trivial and involves risks and problems. First, to help deciding on current DSARs, the system somehow needs to be linked to the current case at hand. The system has to be told about facts of the current case. For DSARs, this probably would have to be done manually. Second, every necessary knowledge base has to, or every necessary knowledge has to be made explicit. This means that at least in manually modeled knowledge bases, subjective opinions or implicit knowledge by the experts would have to be made explicit and be incorporated in the knowledge base. Thus, the knowledge base is just as good as the people who modeled it. Also, and this is very important for the automation of DSARs, GDPR not only contains a number of ambiguous or undefined legal terms, but also provides opening clauses with specific requirements for member states to enact diverging laws. This means depending on the field of law, there might be a whole network of legal rules that could apply, and this would have to be considered. To model all those rules manually, including them in a knowledge base and maintaining this is not only error-prone, but also very expensive work. Still, if successful, it would pay off because anyone could make sure to at least have considered all possibly relevant laws. And regarding the fact that changes in law are one of the main reasons maintenance of these systems is very laborious, the future perspective, however, is quite promising since GDPR is not expected to be changed very often. What I want to focus on within the next months is how the named methods to automate DSARs can be combined to make the most of the advantages of every component. Also, since I only have the legal background, I want to better understand how the technologies work. Looking at the time, I want to stop here and thank you all for your attention. As you can see, this is still a work in progress. So if you have good ideas or further remarks, I'm happy to get back in touch with you now or later via email. You can see the email address here. And Roland, Susan, and Stephen, this is important to me. Thank you again for the amazing time I had at Stanford, for your support before and during my stay. Even in those chaotic times, I've been so grateful and happy to have met you there and to have seen what CodeX is about. Thank you.
Thank you, Ramona. You're very kind. I really appreciate it. And yeah, it was just unfortunate that you had to leave earlier due to the pandemic.
Yeah.
But it seems like you found a new exciting project to work on. Thank you for sharing. And this is very interesting. I think you're touching on a lot of critical issues here. And so my first question would be, what is your, I mean, you sort of present, you capture this, you know, nice idea of a particular system then that would raise all these challenging legal tech issues also. What's your ultimate goal? Is this just, you know, for you want to build like a prototype and use that as the vehicle for your research? Are you using to actually maybe bring this into the market, you know, and be a nice kind of you know, sort of additional kind of output for your doctoral research? What are your ultimate ambitions for this particular project?
Yeah, the thing is, this research is kind of touching practice a lot, but my goal is actually not to build a prototype or to bring this onto the market. Um, my goal is to write my thesis and then to bring the research in this field forward, because I really feel that this is a topic which is so important to work on, and especially to work more on the computational law aspects of it. But I can see the potential for kind of developing this further, but probably not me doing that.
And maybe some of those entrepreneurs who want to build the thing can then hire you as a chief scientist or something while you.
Sure, yeah, we can talk about that.
Your research and your teaching too. So, okay, does anyone else have any questions for Ramona? You can use the text or just unmute yourself so we can hear you.
I just posted 2 in the chats.
Oh. Oh yeah, I can see it. Sorry.
So how would the system cope with semantic data such as misspelled names, initials, and former names, or would this require numerous data requests per name? That's the first question. And how would companies cope with cross-border queries?
Okay, let me just look at the first question. This is quite specific. So if there is misspelled names and bugs in your data, you can always have those problems. And this system is supposed to help for people with rather small databases. So if there is any misspelling and the system is not supposed to really do everything on its own, it's supposed to guide the employee in the first place. So if there is misspelling initials and former names, you have to update your databases. If you can see that that there is bugs in it, then I'd say, yeah, of course, it's always, if you search your databases, and then probably you won't get any results, or you search for what you could do is search for example, customer numbers which are not correlated to a specific name. If you often have several names that are spelled the same way, so normally you would use numbers or identifiers to search for these people. So this can be, to some extent, it can be helped. But second question, sorry, Roland.
Yeah, the second question, how would companies cope with cross-border queries?
You mean from people from outside of Europe, or how is that supposed to?
I was thinking more in case of if you've got a company that has clients in different countries and their data is stored across borders. So if different jurisdictions have got different regulations, how would you?
No, actually, well, the GDPR is applicable in not only in Europe, but in the whole world, actually. So if you have customers or somehow relationships with people being in the EU, then these people can request their data, no matter if your location or if the location of the company is in the US or in India or somewhere else. So this is the broad scope of GDPR and broad field of application.
Right. So then you got a lot of praise from other participants, Stephen and Scott and Olya.
Thank you.
Really like your presentation. Yongsin's asking, how big is your rule system and how big is your ontology?
Okay. Just to put it straight, I haven't built anything. I'm looking at this issue from a very theoretical and from a research perspective. I'm not a data scientist. I'm not a CS student. I only have the legal background, so that is what I can work with. I'm looking at ontologies that are already built on papers that have been published concerning GDPR ontologies and what people do with it. So this is what I have, and this is what I work with. But I'm not building an ontology on my own. I'm the most scientific or the most work I've done so far with regards to that is building workflows. So yeah, sorry to disappoint you in this point.
So and then the last question from Scott, and then we'll turn it over to Victor, is how do you see verification of subjects, RASF, developing differently between Europe regarding the GDPR and conceptually regarding America? Could you see on the horizon a standardized verification process that would be legal in Europe and even in all 200 countries?
Yeah, that would be pretty great if we had such a standard, because what we see regarding GDPR right now is that identity verification is such a hard issue to solve. People are requesting ID card copies all the time. People don't know how to identify their customers. So this is something that the EU really has to work on, and that jurisdiction has to provide clarity with. What I know is that in the US, you use your driver's license a lot, and you use kind of ID card copies are pretty normal. With regards to GDPR, we're always looking at the principle of data minimization, and we don't really like adding more and more data, even if it's only for the purpose of verification of the identities. I would be very happy if there would be some clarity regarding how to best prove the identity of a person. For example, if you have an online account, many people don't use the online account data, even though this data is totally sufficient for placing an order or using this online platform, for example. Many don't do it because they don't know how to do better. And yeah, I'm very curious how that's going to develop. It would be great to have a standard, or at least maybe not for 200 countries at one time, but at least for Europe or for the US.
All right, Ramona, we have to turn to our next speaker, but so great to see you, and thanks for sharing an update on your research. And if you could perhaps put just your email address into the chat, then folks who may have more questions could reach out to you directly. But thank you again. It's great to have you.
Thank you, Roland.
Yeah, stay safe. Thanks. All right, so let me turn it over to Victor and Igor. Are you there, Victor and Igor?
Yes, we're here.
Hey, gentlemen, welcome. Good to see you.
See you. Good to see you too, Roland. Thank you very much for receiving us.
All right, so
let me share my screen.
Well, curious to learn about your Juris Intel project.
That's great. All right, thank you. So it's a huge pleasure for us to be here in this group meeting talking about our work with Juris Intel. So this is basically our team. It's me and Igor. I'm going to be sharing this presentation with him. He's going to be speaking with you in a couple of minutes as well. So Igor is working with development and data analysis here at Juris Intel. I do business development and also data analysis. So we are pretty much two former lawyers trying to make lawyers more confident nowadays dealing with legal information and so on. So that's what we do. We do data journalism for lawyers. So we want to help lawyers to stay informed about trending judicial and tax court decisions. And the way that we do it is by processing sort of 2,000 to 20,000 cases every week using NLP, AI, and graphs. And when we do this processing of information, we deliver this information in 3 ways for the lawyers today. So we have some weekly reports being sent directly to their inbox, on their email inbox. So we do those reports with data analysis from the STJ, which is the Superior Court here in Brazil for federal law, except the Constitution, and also for CARF, which is responsible for tax appeals in Brazil. And those reports are also linked use the data that we collect and present them with the reports. We put them on the detailed way in cards so they can filter the information by the topic of the case, by the winner of the case, by the judge responsible for judging that case, and so on. And we also present this information on a website with some in-depth analysis for the Supreme Court data, so only for the Supreme Court data. So, but the way that we do it, we are wanting to face some problems that it's very big in Brazil. So specifically why we do it. So what is the problem that we're dealing right now?
So thanks again for having us. In the Divine Comedy by Dante Alighieri, there's a warning in the door that leads to hell. It says, "Abandon hope, all you who enter here." And we could put that same warning in law schools in Brazil too, because our legal system is chaotic. As you can see by these numbers, lawyers have a very hard time here because the Brazilian Supreme Court decides over 300 cases every day. And that's just the Brazilian Supreme Court. We have about 80 million cases in our judicial system. And we did some survey some months ago, and almost 50% of the lawyers spend about 2 hours a day trying to stay on top of the legal news. They spend hours trying to get what's the most recent decision, what's good law. So our motivation came from our experience as lawyers. And we think that the current means like books, law reviews, and websites to cope with all these decisions and all this information, the current means are not enough. We need something else. So we decided to tackle the problem from a different perspective. We realized that we needed like industrial scale for treating legal information. So we did that on a piece of code that we call UPDJ, which is a legal data processing unit. It's like a piece of code that is a pipeline. When we get the raw text from the judicial decisions, we do some classification, we extract name entity, and we do some analysis. We build some graphics. We do some graphics with that data, and we write that on our reports. And we do that on a daily basis, because another problem that we saw was that most of the data analysis happens on a very limited amount of time. For example, if a newspaper gets some emails about a political scandal, they treat this information for the article, and that's it. When the article is done, the analysis is done. But we have all this data, all these decisions that lawyers have to navigate to find what they need to work, and they have all that daily. So it made sense for us to have some sort of structure to process all this, a pipeline to process all this information daily. So we can see in the next slide an example where we have a heat map. On the vertical axis, we have the names of the Brazilian justices, and on the horizontal axis, we have some topics. And you can see a red spot there that represents the position of one of the justices in the Brazilian Supreme Court on criminal law, more specifically on habeas corpus. And you can see that he has a very clear dissenting opinion on most of the criminal cases. You can also see there's like a blue scale on some of the justice regarding some other topics. So here, this graph represents part of our daily analysis of what we deliver through newsletters and on our website. where lawyers can see what's trending. They can spot the position of some justices, a group of justices, a panel of justices, and they can create strategies to approach the law with this kind of information. So they have now context, you know, because books and articles on law reviews, they usually focus on one precedent. They just do analysis of one case. And if you process data, if you see data as something broader, like all the cases regarding, for example, freedom of speech, and you put that through this kind of pipeline, you can offer more context to lawyers, and they can think more clearly. They can find the patterns on the data. So we group these decisions, and we deliver that. Every week for lawyers. And Victor can talk about our business model more in detail. Thank you.
Okay, so today, currently, as we were saying, we have this the weekly reports, we have the website and the data interaction interface to present for the lawyers. Today, all of this runs on a free B2C model. So we do provide this information for free for lawyers today. Today we have 3 active data processing units, as Igor was saying, for STF, the Federal, the Supreme Court, from STJ, and for CAF, which is the Tax Appeals Court. And we are running this model today, thinking about a user-driven adoption model. So the idea here is to start with a simple B2C use case, so lawyers can start using it and feeling on a daily basis what happens on the courts and feel the value out of it. And then we move to a bottom-up adoption. So we grow the product and in complexity and value, so we can move then for a B2B adoption or a more complex adoption for that product. So today, our roadmap, our plans to do for the coming months are to increase by 2 the numbers of the UPDJs, as Igor was saying. On November, we are planning on launching that paid version for the tax law report. So lawyers that work within only the tax side of the business here in Brazil, they're going to be able to receive reports specifically for the cases that they want to follow, that they want to research on it on a deeper mode. On December, we're planning to launch that enhanced version of the data interaction interface website that we have today, with more functions, with more things to do on the website, on the interface. And then on January, we're planning to increase the database and bring in more different courts and more data from different places to increase and have more information to treat and send for the lawyers. So that's basically what we do. That's pretty much how we are structuring our businesses, what we are thinking about moving on the next steps. We have here our contacts, so feel free to reach out to us to learn a little bit more about Jurisintel or about the Brazilian system as well. Thank you.
All right. Well, thank you so much. Let me see. So some folks are asking questions already. How adaptable is the UPTJ to different legal systems? And what customization does it need?
So one big problem with natural language processing is that mostly it's trained on data like colloquial speech and colloquial text, like everyday text or literature, not on legal text. It's very hard to find models that are trained on legal text. And that's more true if you speak Portuguese. So to make the unit to process other language like Italian, Spanish, you would have to train the artificial intelligence to find the entities and everything in the text. So it's kind of easy as long as you have enough text and the text is and you have some examples to train the artificial intelligence, the model.
Got it. How do you access the case law? Are the cases published and available in electronic form?
Yes. In Brazil, different from the US and other countries, it's kind of easy to access the data. The judicial court system publishes the cases on their website. It's free, and you also have like a journal, a gazette, where the cases are also published. So you have two ways to access the data. We don't have an API to access the data now, but maybe in the future they will even do that. So it's not hard to find the cases.
Pretty much all the cases today in the Brazilian system, it's they are being like born with in the digital environment. So we have no other cases starting on the physical or paper mode. So everything's digital already right now.
All right, and so this is meant as a service for practicing lawyers, and they pay a subscription fee to the system.
Yeah, that's it. Right now we are doing that data journalism version. So you have we pretty much follow the courts daily, so we can present for the lawyers. As Igor was saying, we have thousands of cases being judged every day. So all the decisions, especially on the tax system that we are focusing right now, a lawyer has to comply with municipal, states, and also like federal jurisdictions. So it's pretty rough to follow that up. And sometimes you have some big cases that everyone knows about it, but sometimes you also have some small cases that happens in the state that no one knows about it. So we are trying to gather all this data and present it on a more journalistic way, but based on data. So lawyers can really feel what's going on instead of just having example of one case to cite or to use for this case. Right now it's for free, but as I was saying, our plans is to release it on monthly subscription mode. So the lawyers are going to pay to use it on the to access that data interface, so they can research for the case specifically that he wants to use or he wants to work on it, and see the data that regards that theme in the federal or municipal or state jurisdiction. Is pretty much that the idea.
Mm-hmm. Yongsin's asking, what are your data sources and what percentage of cases is accessible to you now, both federal or local?
We could access basically everything, every decision made by a Brazilian judge, but now we are restricted to this 20,000 cases every week, because now we are focused on the Supreme Court, on the Superior Court of Justice, and in the Tax Appeals Court. So we're, and these 20,000 cases comes from these three courts only. If we had to process every decision, which we could, if we had enough people and enough machine to do it, it would be millions, because I believe the Brazilian court system produces millions of decisions every day. We have, as you saw, we have 80 million cases currently in the Brazilian system. So, and here in Brazil, a case usually gets more than one decision. It's not unusual to have 10, 15 decisions in one case. It's chaotic, as I said, but that's how it is.
Got it.
And many times
Okay.
that situation comes up to a judge judging the same case in two different ways. So you have that a lot of big uncertainty of what the law is going to be for it.
Okay, so maybe final question from Yongsin. Do you track the entire course of the case from beginning to end, or just the decision?
Right now, we're tracking just the decisions. We don't track what happens in between. We could, because everything is public. Data in Brazil, even that's a very interesting thing, because, you know, on all this debate about data, here in Brazil, we have a very specific situation where data is very public, is very, especially judicial data. So you can have access to everything. You could have get all the steps that the case takes from the very beginning to the very end. There are some cases even in Brazil where people sue mechanisms like Google and other sites for judicial data, because these sites, they get the data from the judicial court system, and they make it searchable on the internet. So if someone's search for your name, they can find all the cases where your name was mentioned. And sometimes people take that to the judicial system, saying that's some sort of damages. And usually they don't have success, because it's a constitutional principle in Brazil that all the information should be public. So we could do that, but we don't do it, because to track all the cases, every step would require a lot of computer power, a lot of people, and we don't have that now.
Got it. Okay, well, great. Well, really appreciate Victor and Igor you joining us, and it's already evening, I think, in Brazil.
Yeah.
And
Yeah, 6 p.m.
very much appreciate you sharing the story of Juris Intel, Juris Intel, and yeah, please keep us posted, and good luck with your next steps. I really appreciate having you here today. And yeah, quick round of applause. And I will turn it over to Giri now. If you're there. Thank you, gentlemen. Good to see you.
Great. Hi everyone. Hi Roland. Thank you very much.
Hey, how are you?
Very good. And I think that the timing is great. The follow-up from both topics, from Ramona and from Victor and Igor, is actually fitting very well what I would like to discuss now, which is
great. Take it away.
Let me try to share the screen, and let me know if you can see it, and in what mode can you see it.
Yes, we can see it. It's a little
fantastic.
Presentation mode.
Excellent.
Try to go into.
Yeah, it's not in presentation mode, but we can see it.
Oh, it's still not in presentation mode?
Yeah.
I see.
Correct.
Oh, that's a pity.
Yeah.
I think I changed the setting as suggested, and at this point, it's not going to go on presentation.
It's not going to work. Okay.
Can you still see the slides?
We can see it. Yeah, it's a bit small, but that's fine.
Yeah, let me fix that real quick. So a bit of introduction while I'm doing it is I'm going to be speaking about electronic access to court documents and the balancing of legal and ethical risks against transparency and innovation. So what we just heard from Igor and Victor is extremely interesting and relevant to me, because I'm looking at how the rules of the judicial system and the public administration allowing for the court decisions to be open, but not only decisions, I'm also looking at court documents, ultimately gives opportunities to the market for legal innovation, for legal technology to develop, as we saw also in the case of Brazil. So if you give me a second, I'll try to share in a form that you can see the whole screen. Hopefully now. Hello?
Yes, this is it's definitely bigger, yes.
Okay,
and
excellent.
Have you tried to go into the presentation mode?
Yes, it is on presentation mode right now.
No, okay, well, it still looks like it isn't, but we still see
Yeah, I changed it.
That's fine. We can see it, just, yeah, it's
okay.
Good.
Excellent. For the sake of time, I'm stopping.
Yeah.
I'm not going to tweak. So the presentation will look at three points. These are adjusted to the presentation. I'm writing a paper right now on the topic. First, I'm going to talk about how do I define access to documents, and also the current state of play, how legal mostly scholarship has been dealing with the issue, and where can we find data for which jurisdictions have open and accessible electronic forms of court documents. Then I'm looking into my basic argument, which is how this topic of e-justice, it belongs to justice administration, this transformation of courts in doing things more digital, meets legal tech, meets the market. And then I'm looking at two things, the benefits, but also the risks of providing open access to electronic versions of the court documents. And finally, the balancing exercise of my research, which is how do you balance ethical and legal issues, considerations, and challenges that come about, and some practical ways that I'm thinking about in order to take this field forward. So defining access to docs, what do I mean by court documents? What do I mean by electronic access? And what do I mean by access? So court documents could be internal, produced by court members, or external, and these are part of these create the records, the court records, and the docket. And they could be produced by various parties, including lawyers, and the whole legal teams around lawyers, but there's also evidence which belongs to third parties. Then electronic, easy, either existing in paper and getting digitized, or born digital material. And then in terms of access, I'm looking at access within the judicial system, so access that facilitates justice administration. And this is important for certain jurisdictions that are not as developed in the e-justice side. They might not allow for electronic submissions yet, etc. I'll bring data from the European Union to see the differences between the various European Union member states in that, and looking into other jurisdictions as well. And then on the other side, public or open access would allow anyone to use the data and anyone to use these judicial documents. The current state of play, we have places and jurisdictions that allow for access to the electronic versions, particularly of court decisions, not necessarily of the entire docket. We just heard about Brazil. There is the accessibility of federal court cases in the United States, and also cases at the European Union courts. This doesn't mean that cases at the member state level are always electronically accessible, but the EU courts themselves are bound to publish their court decisions. And then there's a number of existing studies. I will show you in the next slide data that we have from the European Union Justice Scoreboards that show the progress of states in actually providing electronic access to some court materials, particularly decisions, and other studies that I'm looking at, and scholarly work. Where are we in terms of scholarship? From what I've seen—
Excuse me, I'm so sorry, this is Susan again. Are you meaning for the slides to advance? Because unfortunately they're not advancing.
Yeah, are you seeing the advancement now?
No.
Oh, I see. Okay.
Yeah, if you're on two monitors, there we go. You may have to do it manually.
That's fine. So now you see recent developments.
Yep, we're good.
Okay, so you'll just see my notes as well. Let's do it like that so that we don't miss the slides. Okay, so basically I started with electronic access to documents, outlined the presentation, and we were defining access. Now in state of play, I talked about the public access to court electronic records in the US. I also mentioned the Brazilian case that we just saw. So there's a diversity of the current state of accessibility and availability of electronic court documents, mostly court decisions. Where is scholarship at this point? So far, I've been looking at works. I see this interest in scholarship starting around 2004. That's the first work that I found with studies either focusing on specific judicial systems or comparing. There is an elaborate study on Brazil, for example, and also a few Latin American countries. There are a couple of studies focused on certain EU member states. And then the focus of scholarly work has been this need for the update of the judicial system. Now, the balancing between privacy and transparency or openness of courts has also been attached upon scholarship and has been looked at, particularly in the United States. There's a very relevant case, piece of scholarship from a number of scholars that have looked at it from an interdisciplinary perspective. And one of the authors is Ellen Nissenbaum, who applies her theory of contextual integrity, looking at whether this can help in balancing which information from court data should be available and which not, and why shouldn't we just allow every type of data coming from the courts to be accessible out there. Data from court cases identify people and sometimes are quite sensitive. They involve live battles between individuals, things that not everyone wants to allow for public access. And then I'm looking at recent developments besides the literature study. And I've outlined here a few that are the most recent, and I'm going from the most recent, July 2022, a bit older, in 2019. The recent developments that I'm looking at are not exhaustive, so if I'm missing things, I'm looking forward to hearing your suggestions. And I'm starting with the EU Justice Scoreboard that was just issued. This is the 7th one since 2013 that the European Union started publishing the scoreboards every year. And it includes data for many factors, scoring sort of how accessible is justice in Europe. Among them is also the availability of electronic access and the production of machine-readable judicial decisions. And very recently, there has also been the publication of the roadmap, Digitalization of Justice in the EU roadmap, together with a call for comments upon it and what kind of measures should Europe adopt in order to fast track e-justice, given the given the lessons that we learned during the lockdowns of COVID-19 when a lot of courts just stopped working. And then we have the first figure. I hope this is somehow visible. This is a figure.
I just want, we're about to run out of time, but I want to, since we started a little later, I want to, maybe we'll go a little bit over time, but I just want to make sure that you leave a little bit of time for questions too. And I see you have 28 slides in total and you're on slide number 8.
I'm gonna stop earlier. And unfortunately, I'm gonna just choose what
yeah, just maybe highlight the main points. I'd be curious to see also, if there's anything in terms of the culture that's different, it's just looking at the US or Europe in terms of what people are comfortable with in terms of having about their own lawsuits out in the public, right? I know some people who, with some of these new services that are out there that allow you to find any kind of public information, any kind of lawsuits. Some people find their names out there, and some very, confidential or unpleasant information shared about them in public. And I wonder if there's a different approach that I guess here in the US that's legal. I don't know if there's a different approach in Europe. It'd be interesting to hear your thoughts on that. But I want to let you kind of just wrap up and then just give everyone a chance to ask a couple of questions.
Great, fantastic. And your question hits the spot so that we can go to the balancing. And both in the US and in Europe and in other jurisdictions, the need for balancing, on the one hand, let me look at the balancing exercise. On the one hand, the needs for justice and modernization of our judicial systems, but also judicial autonomy and privacy have been always in place. So the US is not a jurisdiction that is ready to have everything open, and there have been discussions, there have been workshops, including involving judges, discussing about judicial integrity and what are the risks involved for data subjects when everything is open. Now, what happens with the European Union? We have the GDPR, which would probably require us to think about anonymization, and particularly of sensitive data. And there's also the culture of the right to be forgotten, which I think probably is the most important legal obstacle when it comes to data. Another thing that I identify and I speak, I can speak more about it, this is probably going to be the focus of the paper, is data ownership. It is not clear that all court data across jurisdictions is always open in the sense that there's no intellectual property over them. It might sound bizarre that there's intellectual property rights over data, court data, but there was a recent case, Georgia v. Resource.org in the US, which was ultimately solved by the Supreme Court 5-4, saying that legal documents are open. However, the debate is still not entirely settled. And within that, I just wanted to open to a discussion of, how do we think about this balancing? There are a lot of risks that opening up court data comes with, particularly with regard to privacy of parties, with regard to data protection. And now in the world of fake news and deep fakes, we have to address new type of problems that expose parties, individuals, to a technological environment that might take advantage of such sensitive data. So that's pretty much the conundrum, the ethical conundrum that I wanted to put forward, and I'm very happy to share, the results of this. It's an ongoing work, and discuss what our crowd here wants to know. I'm very excited to continue this, and also excited about the links with the previous speakers.
Thank you. That sounds great. So Roberto is saying there are several scholars who advocate for a digital version of the practical obscurity principle to tackle the tension between privacy and openness within court records in electronic format. What is your take about such a proposal?
Yeah, this indeed, and scholarship adds that. I think it's a good approach. I think we need a broader theoretical framework for how to deal with privacy, and I'm leaning towards contextual integrity, the theory that I mentioned earlier. But practical obscurity is also a good measure that follows up on the principles behind having public archives before. You can never silo everything from every type of information from being out there, but you can always obscure information or make it more difficult, adding steps to people that want to access them, so that they need to overcome a lot of obstacles in order to use data, especially sensitive data, when they have been when there has been an effort from the courts and from the public administration to cover those.
Got it. Okay. All right. Any other questions? Yeah, I'm told to ask you to put your email address in the chat so people can reach out and ask any follow-up questions. Olia is asking, will you also, for a fascinating topic to work on, will you also be looking at decisions that contain confidential information from businesses or only personal data of people?
For sure. So one of the points forward is to differentiate fields of law, and start with case studies. I propose a bottom-up approach where basically we look at different fields of law, starting from fields that we assume have less sensitive data, for example, corporate data, business data, which are, depending on how you see it, less sensitive, for example, compared to minors. Minors would be the highest part of the list. And start experimenting with pilots, especially in countries where this is the countries that lag, that are behind in opening up their court documents to the public, and see what works best and what not. And I think that involving judges in this process is quite important. Judges and also the civil society, voices that have a lot of stakes in what happens. The judicial branch is preoccupied by a lot of things. We just heard about the backlog that many courts had. We need to consider what effects would that have upon the institution. And a final thing that I wanted to say, and I meant to say that in the beginning, I'm also biased in favor of access. All my work until now has been on access to knowledge, but I've always been looking at libraries and cultural institutions. When it comes to courts, considerations change. And indeed, there's this balancing of what kind of data is there that Olya also mentioned.
Cool. Well, great. So that's a fascinating topic and really important work. And I want to thank you and all the other presenters for sharing your work with us and letting us kind of get a glimpse into your thoughts and how do you see the future of those questions that you're addressing. And that's super informative for us, and I hope it's going to facilitate new connections also. You might identify some folks who listen to your presentations who might become collaborators with you. So that's also the purpose of that convening. So really appreciate you all. Thank you so much for joining us. Giri, again, please, if you put your email into the chat, then folks can reach out directly if they have additional questions. And yeah, thank you all for joining us. Susan, do we have a session next Thursday or?
Yeah, we'll be here next Thursday, and I'll leave the chat open a little bit so people can pick up this email address from our last presenter. So thanks, everybody. See you next week.
Good to see you all, and yeah, see you soon. Bye-bye.